Now that we've introduced the first topic, and all of the experts have contributed to the discussion of that matter, if counsel have not become involved, it is sometimes necessary to actively draw them in. In my experience, when counsel are new to concurrent evidence, there may be some uncertainty as to how they can best contribute. However, inhibitions generally fall away quite quickly.
Yes, now thank you. That's probably enough from me at this stage. It helps me to understand a little bit about the matter. You understand I don't find this to be an easy exercise. It's not a conventional problem by a long way. Mr. Coles, do you want to start now with methodology? I think I've gone part of the way there, but do you want to continue the discussion?
If you're pleased, there are some matters that we'd like to take up with the expert witnesses. Perhaps if I might commence this way, can I first seek to confirm from the witnesses whether there is indeed a broad general understanding that they share that in this particular case it's very difficult to do a before and after across the board sort of assessment, let's say, in this particular case?
Yes. Yes.
There doesn't, accordingly, seem to be particular dissent about that proposition. Now, as part of the reason for that, the fact that in some instances at least golf courses may come to be sold for a price actually less than the construction costs.
Yes, that is an issue. However, I don't think that is actually a factor that would come into whether or not you would do a before and after of the total value.
Now, is it correct to say that there is no clearly identifiable comparable golf course with a transmission line going through it that could be taken into account by valuers in the assessment process in relation to this particular golf course?
Yep.
I'm not aware of any comparable.
I think, Mr. Wentworth, you may be able to tell us something about this.
Yes, just to answer your first question, I don't believe it's an insurmountable problem to undertake a before and after analysis of this property. I'm not suggesting it's as straightforward as having the luxury of a sale immediately next door, but valuers in their normal course do make adjustments for the differences between the sales evidence and the subject property. So I've adopted a piecemeal approach to this exercise, but also considered the location of where the property is. It's in Coffs Harbour, and how that location would affect the potential of this property. And I believe a before and after exercise can be supported.
And can I ask this one to Ms. Burke? Would you be of the same view as that expressed by Mr. Wentworth?
It depends whether your question relates just to the golf course or to the master plan as well.
Yes, I see. Very well then. I think, if Your Honour please, that's all I wish to inquire of the expert witnesses on the methodology issue that we're waiting to find.
Yes, thank you. Mr. Reries, do you want to join the discussion?
Yes, Your Honour. The sale of the property to the applicant was by the contract date of the 10th of February 1998, and the easement was resumed on the 5th of February 2001. So there was a period of 3 years between contract and resumption. And the only factor that changed in that period with respect to the property was that the master plan consent was granted by the council, and there were two options entered into by the owner of the golf course, and they were over lots N and O. And both of lots N and O, although they've have slightly different zoning, and there's a foreshadowed support of a rezoning by the council, give you a reflection of market value.
Sorry, give you a
market value.
Well, look, I don't think in relation to the properties that were under. And look, there may have been some adjoining owner who was trying to influence what was ultimately played. But the owners did want to do something in relation to the golf course.
As you can see, we have edited the transcript. The full version makes for boring television. However, you can now understand that the process allows the experts and the advocates to contribute to a joint discussion of particular topics. It is important that the judge maintains control of the discussion and, when appropriate, moves it forward.
I'm sorry, I think I've diverted us a little. Where do you want to go now, gentlemen?
For our part, Your Honour, there are some further matters we'd like to explore, but I don't think I need to explore any further the issue which Mr Blaxland has just developed. We'll leave that to submissions.
Well then, just looking at our agenda, as far as our topics go, we've now covered, I think, methodology and individual approaches.
Indeed. There is if I may turn to a fresh matter, Your Honour, there is a matter I'd like to raise in the first instance and direct it to Mr Blaxland. I think, Mr Blaxland, you have seen a document which is on yesterday added to the evidence as part of Exhibit V, is that right?
As you can see, the discussion is now moving fluently with all of the participants involved. Experience also indicates that the level of tension in the courtroom falls away in the concurrent process. The adversarial contest gives way to a genuine exchange of expert views. Another benefit from the process is that because the experts know that they can be asked questions directly by their colleagues, the quality of the evidence significantly improves. The half answer in the hope that the advocate will not know what has been left out is no longer possible. The wrong answer can be directly exposed by a question from another expert. Let's show you now how the witnesses can become involved in direct responses to each other's comments. It's an example from the trial where Mr Blaxland commences the exchange.
But the type of townhouse development that you will get in this area, well, you know, they're going to be sitting down and making assumptions as to whether they can get the majority of those in as they appear. They're not going to be sitting down looking at the bits and pieces and how they can move the pieces and so on and so forth. I mean, well, you know, if they can go beyond that, well, all the better for them. But basically, they're going to be sitting down and they're going to be looking at what the essence of the principal approval is.
I might, Your Honour, if I could just maybe add my views on that. I was previously asked to have a look at Mr Blaxland's assessment as it appears in Schedule 1 of his Statement of Evidence and replicate that, which I have done. I was then asked to apply Warren and Cashman's figures that were discussed this morning, and once those figures, if accepted by the court, if the court finds that Mr Blaxland's basis is correct, and then you apply those costs, it results in a loss of $578,000. Really, it doesn't matter where the units are, whether they're within the easement or... And if you accept the $495,000... What should come into it, as Mr Blaxland has done in Schedule 1, is that he's included development costs of 10%, which is not included in the hypothetical development analysis handed up this morning. There are other costs there, as I say, costs that were project specifics which have been excluded from Mr Blaxland's exercise. We've discussed air conditioning and also site infrastructure excluded from the costings that were provided by Warren and Cashman.
Your Honour, that's just simply not correct. And I mean, I haven't seen Mr Wentworth's exercise, but if he's simply just added in figures that the quantity surveyor has suggested that I've already included, then there's a whole lot of double dipping going on. In regards to the interest, I haven't seen that document that was handed up, and so I'm not quite sure what Mr Wentworth is saying there, but I have certainly included more amount for interest than the quantity surveyors have suggested in my exercise, and that has not been excluded from that exercise. And so I'm not sure where Mr Wentworth comes up with this negative figure if he's simply adding in figures that I've already included across a number of different elements. I mean, if they've already been allowed, then why would you allow them again?
Your Honour, I've been very careful not to double dip. I have a copy of my calculations. I only have one copy here.
Yes, thank you. If you can just give it to the officer, we'll get it copied. Some people have expressed a concern that if there are credit issues that need to be raised with a witness, this cannot effectively be done during concurrent evidence. This is not the case, as the following extract from the trial shows.
Mr. Blaxland, you began your first report's analysis at page 40 in Schedule 1 with an in globo per unit loss of $56,000 on this hypothetical exercise. Is that right?
Yes, that's right.
And to arrive at that, you assumed there'd be gross realisations based on a sale price of $495,000?
Correct, yes.
In today's exercise, Exhibit Y, you've assumed a higher sales price of $530,000. Is that right?
Yes.
But you got an in globo land value per unit lost of $45,760. Is that right?
Yes.
So that what's happened is that the price of the land has gone up, but the value's come down in your analysis.
So price of the land, you mean, or price of the unit?
Well, the sale price of the units has gone up, but the land value has gone down.
Yes.
And you've reduced the risk. Is that right?
Yes.
Doesn't make any sense, does it?
Well, it's just a calculation, which is relative to the agreed costs from all the other experts in relation to infrastructure and landscape and the like.
I suggest to you that what you've done in Exhibit Y has no intellectual integrity, does it?
I reject that.
Finally, it is necessary for the judge to ensure that everybody has had the opportunity to put all relevant material into the discussion.
Yes, thank you. I think that brings us to the end of the topics that we needed to discuss, but is there any aspect of the matter that any of you wish to say anything further about?
No, Your Honour.
Yeah, right. And what about you, gentlemen? Mr. Coles?
Would Your Honour just pardon me while I speak to Mr. Hemming? Not if Your Honour, please.
And Mr. Aries?
No, I'm not part of it.
Well, that brings us to the end of your part in this case, but thank you very much for your careful thought and attention. But you're now excused and free to go, but of course counsel may wish you to stay to help them later in the case. But thank you very much.